you'd normally be seeking to protect would be trade connections, goodwill as well, trade secrets and other confidential information. As I say, there are some implied terms that protect those anyway, and commonly there are also terms within the employment contract to protect confidential information, or in settlement agreements when people are leaving the company, which I'll sort of bring up again in a bit. And things like protecting the stability of the workforce, obviously protecting, I mentioned trade connections, which, client information, supplier information as well. If you've got good contacts with suppliers, you want to protect those. What constitutes as reasonable is going to depend on the circumstances. Factors, affecting reasonableness vary widely, but, include scope, duration, which is obviously is one of the things we've had questions on, is obviously something I think we get questions on quite a lot. How long can I restrict the employee for? What's reasonable there. Geographical location is another thing to consider, and you'll see ones that say, you can't compete with us in a 50-mile radius. If I'm based in Chester, if you say that in Chester, that it's sort of, you're almost stopping people from, not just Chester but Liverpool, Manchester, depending on how big the radius is. So you do need to consider those things, and that may be legitimate if the legitimate has a particular business concern that it's trying to protect. That's what it boils down to. So the types of restrictive covenants. We've got non-compete restrictions, which again, I'm going to talk about in more detail anyway, but broadly speaking means restrictions on the former employee going and working in a similar employment for a competitor. And again, in the way that you draft it, you can obviously limit that. So like I say, you could put a geographical restriction on it. You could specifically name competitors, which you see quite often, in fact. Especially in a small niche industry, you might say you can't go and work for this direct competitor or a list of competitors, or working in that particular type of service, even if you're not, so you could say that I couldn't go and be an employment lawyer in another firm, but I could go and be a lawyer generally for 6 months. There's non-solicitation clauses which prevent the poaching of clients and customers, suppliers of the former employer. So that's the employee specifically going and trying to solicit in those clients or customers or suppliers. But then there's non-dealing restrictions, which are arguably less restrictive, more restrictive, because so non-solicitation would be less restrictive in a sense, because what they're doing is stopping the employee going and grabbing your clients away from you. A non-dealing restriction would be preventing the employee from working for or engaging with that client, that supplier, even if the client approached them. So they tend to be a bit more restrictive. And then you've got the non-poaching covenants, which prevent an employee from taking employees with them or poaching former colleagues, and which I think sometimes people underestimate how useful and important that can be, because you do sometimes see people, a sudden exodus, which you don't really want necessarily. So if I go on to sort of tips for the employer in recruiting staff, and as I said, you're going to have a chat, I think, with Paul and Joe. We'll have a talk about recruitment generally, but in terms of what you need to be thinking about when you're recruiting new staff, what kind of covenants are appropriate to go in their contracts? Do you want any covenants in their contracts at all? First of all, you want to identify your commercial objectives at the outset. So I mentioned that legitimate business interest. What are the interests that you might be trying to protect? Why would that be appropriate in this particular contract for this particular employee? For example, if you're employing sales staff, very common that sales staff will have non-solicitation and non-poaching clauses, because they may have regular contact with clients. They develop the book of clients, and so you don't want them taking it with you when they leave. But you'd still need to think carefully and realistically what would be reasonable in terms of things like duration and geography. There might be also particular standards in your industry that can be taken into account. They may set a guideline for what is reasonable in that particular industry or in that type of job. Like I say, if it's a sales type role, The other thing to always consider is going to be the seniority of the staff. It's rare to put really onerous restrictions in a very junior role, whereas someone more senior, where they have a lot of client contact, where they are maybe bringing clients into the company, you want to keep the clients, um, that's where you're going to want to have more appropriate restrictions. But you should always avoid a blanket approach, and obviously consider the length of the restrictive covenant. 6 to 12 months, we've written here. Actually, there's no set time, of course. The courts have traditionally said that up to 12 months can be reasonable, but again, I think it depends on things like the seniority of the employee. There are some cases where longer restrictions have been upheld, but they are very much the exception. And again, the court will look at these on a case-by-case basis. So they're going to look at, what is the interest trying to be protected? How wide is this restriction? If there's one very focused restriction that's more than 12 months, I suppose that might be more likely to be enforceable. Don't use template restrictions and a blanket approach, as I've said. The other thing is, in the way that they're drafted, you want to try and draft them so that they are severable. This blue pencil test, you run the risk, if they're not well drafted, of all the covenants and even potentially all the employment contract and other protections in the employment contract being thrown out by a court. If you can't run, the reason they call it the blue pencil test, you can't actually run a pencil through, cross out the offending bit, leaving everything else unchanged. And if it still all makes sense, then it's okay and it's severable. And even if unfortunately you can't enforce that particular covenant, at least the rest still stand. If they're drafted in a way so that they will depend on each other, then you've got a real risk of losing all of those restrictions and not being able to enforce all of them. So it's an important thing to consider. It is obviously where having a professional legal draftsman draft it, a professional lawyer draft it, is helpful. And we can consider, obviously, when we draft them, we will talk with the employer, we will talk with HR about what is being protected, about what reasonably needs to be done. Warranties and obligations. This is sort of referring to considering whether an employee has entered into restrictions with their previous employer. So you may want to get them to warranty within their contract when they're signing up, when they're accepting a job role, that they don't have any restrictions already. You don't necessarily want to be involved in a case that you've induced an employee into breaching their restrictions, which I'll talk on a little bit more on the next slide, I think. But you want to maybe have some warranty, some confirmation from them that they're not restricted when you're recruiting someone new. And I'm sure Joe can talk to that. And similarly, in terms of obligations, you may want, when you're drafting restrictions, when you're drafting restrictive covenants, we often put a clause in which obliges the employee to show those restrictions to any new employer. So when they leave, they have to, when they're being recruited to a prospective employer, they are supposed to show under breach of contract, they're supposed to show it to the new employer. That way, the new employer knows what they're getting into, and it actually potentially, if you're the old employer, the former employer, you've got more of a case against the new employer, because you can say, well, the employee must have shown you those restrictions, you helped them breach them, and you may have a case against the employer, albeit those are difficult cases to bring. Keep restrictions under review, and I think this is a key one. So often you'll see stuff, I'm seeing stuff now which won't pass the tests that I highlighted earlier. Legitimate business interest, looking at scope. You'll see 2-year restrictions which just are really unlikely to be enforceable because they haven't been kept up to date. Now, the most likely time to do that is when there's bonuses, promotions, pay rises. Part of the reason for that is you're going to need to give new consideration if you're going to change the terms, essentially, of the contract of employment. And so, that it's conditional on you want to make sure that that bonus is maybe conditional on entering into new restrictions. Again, though, you've still got to consider, probably in that case, what you're doing is narrowing actually the scope of restrictions, in order to make them more feasible. But if we're talking about a promotion where someone is becoming more senior, it may now be appropriate to give them something more restrictive. If they're now having more contact with clients or senior clients, or they now are more in your supply chain, you may want to protect that supply chain. You may want to protect those clients by bringing in new restrictions. So I think I've over talked on that a little. If I hand over to Paul and Joe to talk about recruitment and that sort of thing, and maybe I'll just follow up with this sort of thing of bookend it, if you like, with losing staff. When your staff are going, what might you want to consider? But Joe and Paul, what do you think about all of this? What's your experience, Joe?
My experience on all of it.
So I think what often is the problem is that what we find, particularly as solicitors, is that the client, if it's a company client, will come to us, say this employee is leaving or they've left and they're in breach of the restrictive covenants. And then we say, well, let's see the contract. And the contract arrives and they produce this contract of employment from like 2004, when they started in as a relatively junior member of staff, and they go, they've got restrictive covenants, let's sue them. And then when they've left, they were actually like, second in command of this large company or medium-sized company. And we say, well, you employed them, as an admin or as a temp or something like that at the start, and you put these restrictions in, and now they're in a senior role. So how is the court ever going to be able to enforce these restrictions? Because basically the job that you're restricting here is completely different to the one that that they were doing when they left, or they're doing now. So I think what we're saying, what Michael's main point is that you need to think about it at the point you're employing people. And that's why, it's interesting to ask Joe. So in terms of you, Joe, when you're acting for probably individuals initially, and, as in the applicants who are coming to you to try and get a job, do you have conversations? Do people say to you that they're anxious about restrictive covenants? What is the general kind of mindset of individuals who are in the sort of looking for work? How do you think?
It's hardly ever discussed. From the candidate point of view, they just want a job and they'll deal with that issue when they get the job. They don't want to bring it up at interview stage or at CV application stage. They just want to get into that employer.
That's interesting.
And then they will speak to the employer after they start and say, this is the situation, over to you.
By the way, I can't do this for 6 months or whatever. Yeah. So
that is up to the employer to really discuss. Now, me employing staff to work for JF Recruit, I have those conversations with applicants who want to work with me, because I understand it. But I can't speak on behalf of lots of different employers. And they certainly don't discuss that with me regularly or very often,
right. Okay.
Both from the client point of view, but especially on the candidate point of view. It's just very rare. We deal with sales roles, but they say, we've got all the lists. 25 years ago in sales, you would go away with a paper list, wouldn't you? And nowadays it's all digital. So very easy to copy a database and take it with you. And so, they will turn up to an employer and say, here's the list of all the clients that I've dealt with over the last 2 years. It's worth 150 grand's worth of business if I can contact them now. I'm not too sure what my contract said, but I'm willing to go for it if you are. And that's when the employer then will contact you guys and go, oh, what do we do?
What's going on?
If the question was asked at interview stage, it may put the employee off, but because they really want that candidate, so they both want each other, but they're not prepared to discuss.
Yeah, it's interesting that, and I think, you know, I mean, we don't often see sort of job offer letters, do we, Michael? I suppose, but until things have gone wrong, but it's not that common that people are kind of open about the restrictive covenants and recommend that, you know, people might want to take legal advice as to what they're agreeing to. Usually what happens is they offer the job and everyone's thinking, well, how much am I going to get paid? What kind of hours are going to do? How many holidays are going to get? Am I getting a car? Am I getting a mobile phone, etc.? All the benefits of being an employee. And then the company just kind of sneaks in towards the end of the employment contract, you know, a set of restrictive covenants. And at the time, the employee's thinking, oh God, I'm made up to have a new job, I'll just sign. But that actually doesn't help the employer necessarily either, because that, you know, you have to consider one of the things that the court will certainly consider is what was the mindset of the employee when they entered into the contract. And if there's any sort of uncertainty as to whether they didn't know what they were signing, that will certainly go against them. Often it's kind of sort of it's commonplace that in the event of a court case between an individual and a commercial entity, and in the event of any doubt, the tribunal or the court will always side with the individual, because they will say, well, the company had the resources and the means to make sure that the employee knew what they were signing. They've just gone along and put the name on a bit of paper type thing. Now, that's not to say that's always the case, but generally the odds will be stacked against them. And as I say, we do never really see it in that regard. So, Jo, have you ever had any experience yourself with restrictions?
So as a recruiter working for previous employers, my last employer before I started my own business, well, that was a big question, because on the exit interview, when I said, you know, I'm going to leave, I'm going to start my own agency, I was really honest. And they said, well, yeah, you know, you remember you are contracted out for 12 months. And I had about 150 grand's worth of business to take with me. So I said, okay, yeah, no problem. I took the contract to a solicitor in Chester, and they said, totally up to you. You can try and contact those clients and recruit for those clients from day one, or you can wait 12 months and then you are open to deal with anybody. So a couple of my friends had done what I had done and left an employer to start their own business. And they had been taken to court, not from my previous employer, but from other companies. And they went through court proceedings, and one of them had to pay $5 grand. Now, thinking back to that, I was thinking at the time, I've got a new business. I don't want any bad publicity. I certainly don't want to be stuck with a lot of legal paperwork. I will stick to the wording of the contract. I told all my clients who were ringing me saying, Jo, I've got vacancies. And I said, I can't speak to you until the 13th of June, 2014. And I had the post-it note above my computer, and I couldn't speak to them or take any phone calls. I was just messaging saying, I can't deal with you because I don't want to go to court, and I don't want to be, I don't want any legal fees. So I just went out and got new business for the first 12 months. And then 12 months in, all my old clients came back to me, and we're still recruiting for them now, 8 years on. So I was a good girl, really. I stuck to the terms rigidly, and because I just didn't want any bad publicity, and I didn't want any big fees. You know, in your first year of business, you don't want any surprises.
Sorry, go on. Carry on.
So that's what I did, and a lot of my friends did and didn't do the same that I did. Some were left alone. Some got legal proceedings against them. Some took it to a degree and then backed off, and came to an agreement. So yeah, there's all sorts of stories, but I was.
Yeah, I have to say, from our experience, recruitment is certainly a very certainly an industry which is very hot on restrictive covenants, because there's kind of two spheres to it, isn't there? There's the clients, as in they don't want you, because obviously the recruiters have the relationships with the clients, that's who they're recruiting for, and the business, the recruitment company, doesn't want to lose that business, which is obviously the most important side. But also, and what also can annoy recruitment, so they have a potential candidate which the employee has got to know through the recruitment business that they're currently working for, and then 3 months later they've changed jobs, but that candidate goes direct to them. Then who's won the thing? And recruiters are, quite regularly on the phones with us saying to, this employee's left and we've got they've got restrictive covenants, they can't be doing that. And then when we go back and look at all those tests that Michael's just been through there, and we actually look at them, it is quite difficult. And as you say, to go after an individual, it's not a straightforward process and can be expensive, which we'll touch on in a minute. All right, so in terms of actual non-compete, so these are the ones that are stopping people going into a competitor, competing business. There is currently a consultation underway to look at the removal of these entirely, or perhaps, if not entirely, a new way of working them, which would probably give a lot more clarity to businesses. I think it would probably result in them being more open with individuals, as we've said, that it's quite apparent that they're not at the moment, and also really allow businesses to make a kind of commercial decision on whether actually they want a restrictive covenant. So Michael's got a few slides just to go through what the actual consultation proposes. Off you go, Michael.
Yeah, thanks, absolutely. Let's get the slides back up. Yeah, there were just a few tips on when you are losing your staff, when your staff are leaving, and you may want to consider enforcing your covenants. Before I get into the non-compete consultation, we sort of touched on this a bit anyway. Obviously, if employees are on notice, you can make sure they're aware that they're aware of the restrictive covenants that apply to their contract, and it's good practice to remind them they've entered into them. If you're doing settlement agreements, it's very common and very sensible to reaffirm existing restrictive covenants, or even to pay some consideration for them entering into new restrictions. That might be appropriate, particularly if your existing restrictions are possibly not enforceable, too wide, too long a period, or so on, or just the business has changed or they've become more senior, so you may want to make them even wider. But it's going to depend very much on the specific circumstance if you haven't kept those kind of restrictions up to date for their appropriate level of seniority. You may want to limit, during notice, you may want to limit access to strategic meetings and confidential information. You may want to put them on garden leave. It means you've got that little bit extra control, and it's commonly used in conjunction with restrictive covenants. Having a garden leave contract, therefore, clause in your contract of employment gives you that flexibility of saying, we're going to put you on garden leave for your notice. One thing to bear in mind is that, generally speaking, you don't have to, but if someone is on garden leave, it is generally considered appropriate that it will eat up, if you like, the period of the restriction. So if you've got a 12-month restriction and they're on guard, if they're someone very senior, they may have 6 months notice, they're on garden leave for 6 months. The tribunals are much less likely to find that the full 12 months restriction is going to be enforceable if you're saying they've got to have their 6 month notice period, then a full 12-month restriction. Just much less likely to be enforceable. And commonly when we draft them in the contract, we'll draft a clause in that says, whilst you're on garden leave, it will reduce the amount of the period, the duration of the restriction, to make sure that it's more enforceable. Obviously, a lot of what we've talked about is about making sure the employee, and also potentially the new future employer, is aware of the restrictions. That way, if you've got them signed saying they're aware of them, it's harder for them to argue that they didn't know they existed, which is obviously another way that they might try and fight the enforceability of them. And again, you can get them to sign a thing saying they've had legal advice, especially with something like a settlement agreement, and everyone agrees that they're fair and reasonable and they're no more restrictive than they need to be. Breach of contract by the employer, we have touched on. Essentially, you need to a claim against the new employer is a tricky one, but obviously they've got much deeper pockets if you're looking for financial compensation. But you would need to show you had a loss arising from the breach, and you would need to show that the employer had induced the employee to breach those restrictions. So it is difficult to do. In terms of remedies, the first port of call really is an injunction to stop the employee. Before you get to an injunction and making an application for an injunction, what I think we commonly do, and I'm sure Paul will have done this as well, is if we're acting for an employer, the previous employer, the ex-employer, we will write a cease and desist letter and say, we want you to sign these undertakings to say you're no longer going to breach these terms. And that seems to fit with what Joe has mentioned as well. Another thing is that, that may be an opportunity for a discussion to go back and forth between the outgoing employee, the former employer, about whether maybe they'll waive a few of the restrictions, which you can do unilaterally, and which I will talk about it in non-compete as well as part of the consultation. So maybe there's specifically, a set of clients that they don't want to be taken with, in which case you may want to kind of, amend the restrictions that are in place and agree some things and get the employee to undertake that they're definitely not going to breach the other ones that you still want in place. That can mean that they're much more enforceable, they're much more reasonable, and something like an injunction is going to have much more traction. In terms of remedies for financial loss, you need to be able to show that you had a loss arising from this employee, for example, poaching your clients. It's obviously achievable, but you'd kind of almost need to show that that employee leaving had a direct impact on your turnover, and it obviously happens, but it can be a tricky one to prove. So those are kind of the headlines. If people have specific questions about those areas, then we're more than happy to pick those up in the Q&A. But now I kind of want to talk quickly about this consultation. And first of all, why are they targeting non-compete clauses? This is the consultation documents. Should probably get in reverse, actually, I haven't mirrored, but there you go, non-compete clauses. It says here, to support our economic recovery from the impacts of COVID-19. Now, this is important because they actually did a consultation in 2016, which makes you wonder why they're bothering again. And frankly, the answer seems to be the effect of the pandemic. So because the consultation they did in 2016, they decided they didn't need to take any action. They were going to leave things as they were, with the courts enforcing stuff that was reasonable. Clauses that were reasonable and protecting a legitimate business interest. But they're looking again at them because they're trying to drive through innovation and movement of employees and movement of ideas, and non-compete restrictions specifically seem to restrict that kind of movement, that kind of innovation of ideas going from one company to another. If someone's suddenly got to wait 6 or 12 months, then even if they go to a new employer, then they can't function in that particular service or trade in that good or whatever. Then it can restrict. It's a restraint of trade, and there's a public policy decision at the moment clearly to try and stop any restraint of trade or reduce it, so that we can get the economy moving, get people back into work, get businesses competing, because of course it's good for capitalism. So that's what it boils down to. So they're maximizing opportunities for individuals to start new businesses, which I think we're going to see a lot of, and also to as it says it's here, drive the economic recovery. Paul mentioned what the main proposals are. There's two main proposals. The first option is mandatory compensation for the period of a restrictive covenant. A non-compete restriction, I should say. The main idea is that this comes from some countries in Europe particularly already have compensation as part of their how they approach restrictive covenants, particularly non-compete clauses, and so it's kind of part of the culture within some other countries that employees are compensated, and that is then, it's anticipated, means that employees are less likely to try and breach restrictive covenants because they're being compensated for their restraint, if you like. Employers are more likely to consider whether that restriction is needed because they're paying money during that period. And so they, particularly with non-compete clauses, which again they're concerned about the restraint of trade, it means that employers are more likely to focus when they set up those contracts of employment, or as I say, when you're updating and people being promoted. You know, I think that's a big question, you know, which I'd be interested to hear if any of you have a view on, as to whether that will make you think twice about how you go about drafting non-compete clauses in your contracts, whether you would stop using them altogether, which is one of the questions in the proposals, whether, and you know, that they also ask this question of what should the suitable level of compensation be. Now they set out 60%. There's sort of tick box questions, and they say, you know, should it be 60%, 80%, or 100%? So to give you an example, if you've got a 6-month non-compete clause, you would pay 80% of, I believe it's base wages, so obviously nothing like overtime, but 80% of salary to that employee for 6 months. Throughout that 6-month period, you wouldn't do it as a lump sum, I don't think. But obviously they say or other, so there are other options as well. I think I'd be very interested to see how this goes. Obviously, we don't know what the plan is. I think of the two options, the other being banning non-compete clauses altogether, mandatory compensation is going to be the far more likely. I think the reason for that is that it will, in most cases, focus employers' attention on whether they really need that non-compete restriction. It will reduce the restraint of trade, which is the government's stated aim. And also it means that employees are more likely to actually comply because they're getting paid for it. But I think if you make the compensation too high, then obviously employers, you know, they're going to stop using them. It's not going to be worth it. Or you just put someone on garden leave, which would be the other option. That may cause problems in terms of recruiting replacements whilst someone is on a long garden leave, which I see Joe nodding her head on. But at the same time, at least, you know, it's going to depend on the circumstances. But you know, you wouldn't want to be paying someone 100% of their salary whilst also having just recruited someone to replace them, just so that they don't go off and work for your competitor. You're much less likely to want that non-compete clause in there. So something like 60 or 80 might be more appropriate. 60 may be too low because you know, what will happen is employers will start to just apply it across the board on the basis that it's not going to cost them too much. And the other question that comes into it, which I think is actually on my on the next slide here, the unilateral waiver of the non-compete clause. So the other issue is whether you're paying or not, the employer has the option to unilaterally waive and not, you know, the non-compete clause before the employee leaves and say, you know, we're not going to hold you to these, which they may well do if they're going to have to compensate them during their restricted period. But what the government is concerned about is that employees may act differently during their notice period or in their last few months up to the termination of their employment in the way that they job hunt, because they think that they're under a non-compete restriction, which the employer then suddenly just says, no, we're not going to hold you to that, and so they're worried that it's going to affect it. So this mandatory question here, sorry, this complementary question of unilateral waiver.
Oh, sure, sorry, hang on a second. No, I'm just trying to turn the sign.
Okay. Little interruption. If anyone has a question and wants to jump in, I'm actually quite happy to chat about this. How are we doing for time? Yeah, so we want to get onto those Q&A questions. I won't talk more on these. But the point that this question about the unilateral waiver of non-compete clauses, they give an example. They don't want employers to sort of, you know, say, yeah, we'll compensate you 80% during your non-compete clause. When you start with that employee, you put that non-compete clause, quite a strict non-compete clause in their contract, and then just before they finish, you say, no, we're not that's fine. We'll withdraw it because it could affect how the employee job search is. But they're saying what it might do is they might offset each other, so that if you've got a 6-month restriction, if the employer unilaterally waives the restriction 6 months before the termination of employment, then it won't cost them anything. But if they do it 3 months, then they'll have to pay 3 months of that compensation anyway. So that's one of the proposals. And again, I'm sort of interested to see what people think about that. The other main option is obviously banning non-compete clauses altogether. There are countries that do that. Unfortunately, I seem to have lost my note on it, so I can't see the actual country that does it. Let's see if I can pick it out in here. But I think in Australia they're banned. And so obviously, again, they're curious and they're asking employers whether you think it's going to affect how it would affect your trade if they did ban it completely. And they're asking, if they're not banned, what could they consider a statutory limit? So obviously at the moment we've said the courts tend to enforce up to 12 months. Again, that's going to very much depend on the legitimate business interest that's being protected. So 12 months may even be too long in many cases. But again, they're asking, should there be any kind of statutory limit? My suspicion is that I don't think they'll put a statutory limit on. I'm not really basing that on any kind of information. We don't have any stats yet. Obviously, that's the point of the consultation. But just chatting to employers, chatting to colleagues, I don't get the impression that it would be in employers' interest to set a standard.
No, I agree with that, Michael. I think that it's too restrictive because they always have to reflect what the actual needs of the business are. So it might be appropriate to have one business have it for 3 months and another one for 9 or 12 or even 18 if it's really
I think it's too restrictive just to give a general. I think if you said there was a maximum of 12 and that was set in stone in statute, everyone would just put 12 months in the contract from day one without really thinking about what's appropriate for that individual. So I totally agree with that. The other thing, I've just really quickly touch on that first bullet point on this one. They're also suggesting they might consider an obligation in statute to disclose the exact terms of the non-compete agreement in writing before they enter into the employment relationship. So when you send the job offer letter, you would also need to send the restrictive covenants. I'm not sure what people think about that. Joe, you may have a view on whether that would be a good idea or not. I think we better move on to the questions. We've got about 15 minutes left of our session.
Yeah, I mean, I think what you're probably gauging from what Michael's touched on there is the proposed is very much with a focus of actually planning at the start. The problem is that people do it at the end and then think, oh my God, we've now got this problem. Whereas if you actually plan at the start, then that gives you much more scope to be for them to be enforceable. And I think also, if you're actually having to pay for them, then as I say at the start, it becomes a commercial decision. What is the financial risk to our business as against how much do we need to restrict this employee? Okay, so we have had some questions. We're trying to keep, we have kind of reworded some of them to keep them as sort of general rather than give such specific answers. In terms of quickly, Michael, the consultation is obviously now closed. Do you know when it's going to?
I don't think there's an answer to that. It closed on the 26th of February, so it's relatively recent. You know how these things go. I'm not sure if I'll see if I can check that while you're answering questions, but I'm not aware that there's actually a date proposed for a response at the moment.
Yeah. I mean, I think what we expect is that at some point when Boris has got 5 minutes to think about employment law, there is going to be some sort of plan for the, to bring back business or whatever he's going to bloody call it. And it's basically, so there will be some of that. And, we may see, we've already talked other issues that we may see tribunal fees being introduced. And there may be it may form sort of a set of kind of changes that we're all going to see in the not too distant future, but we don't actually have a date yet. So the first question that we've got on was that we got asked it several times, which I'm going to just deal with now, is how enforceable are restrictive covenants and what kind of timescales are best? Well, the general rule I have to say, which employers won't like, is that they are not enforceable. The courts do not like restrictive covenants because they are entirely against restraint of trade, free movement of workers. Obviously, that organisation that the UK used to be part of was very keen on. I don't want to mention the B word, but yeah, that's we are obviously now no longer a part of the EU. So whether this kind of thing is actually connected to that, I don't know. But interestingly, Michael, didn't you say that there's a few countries, European countries, have already adopted this kind of model?
Yeah, that's right. I don't know which ones they are. I'm gonna have to find it in
Holland.
the
I think in
consultation.
Holland I've got one.
For some reason, I've lost some notes.
So you really must focus back on whether they are reasonable, and that really factors in timescales. One of the classic examples, and it is that I've seen a lot over the years, is hairdressers tend to have these very wide restrictive covenants in their employment contracts to say that they can't work in a very large geographical area. Now, it's not uncommon that most hairdressers don't live too far actually from where they work. People don't tend to travel great distances in that industry. So the idea that an employee, a hairdresser, couldn't work within 50 miles of the salon would be completely unreasonable and therefore never would be enforceable. The other thing is time. Michael said 12 months can be, as a general rule, is kind of the max. I am very reluctant to advise employers to go beyond 6 months unless they have got a real need. Now, obviously, the client will always say to me, "Oh, we'll get as long as we want," but you've got to balance the term against the likelihood of being enforceable. So the longer the term, the less likely it is that you're going to get an enforceable. So while you'd be better having a shorter term, you know how long you've got because you probably are protected, and then you've got that, you've got that period to plan and make arrangements. And if you've got that client that you're worried that they might poach in 6 months, what can you do to build that relationship with the client in the meantime? You can't just sit there and go, "Oh, well, they might take my client." You make sure your client stays. So it's
worth considering as well. Your employee may well, or your ex-employee may well, go and get legal advice. And if the legal advisor is telling them it's not enforceable, even if you're wanting to kind of push towards asking them to cease and desist in breaching that covenant, if they're getting legal advice saying it's not enforceable, even if you're not prepared to challenge it in court, but you're trying to effectively intimidate them to
Joe, on that point, do you ever have employees saying to you, "I've got these restrictions, what should I do?" And if they do ask you that, what would you recommend generally?
For my employees, or
if you had a candidate, not rather an employee,
they very, very rarely bring it up.
Do they? And if they did, would you say, "Don't worry about them," or would you? I
would give advice as what I did is go and see Paul and Michael.
Well, I'll sell that one. I got it out of you in the end.
Go and get legal advice, because you will advise that employee, like the solicitor did to me, it's your decision, but blah, blah, blah. And every contract is very different. So
definitely. And even Michael and I could see a set of restrictive covenants, and we share an office, and we could quite easily disagree as to the level of enforceability. You will do well to find a lawyer who tells you, "Oh, definitely these are enforceable," or "definitely they're not enforceable." Now you'll get a varying degree of how likely they might be enforceable or not. From my experience, you'll never meet a lawyer who gives more than 70% prospects of anything happening. But the reality is that even if you could come to see it as an individual or as a business, you could come to see a solicitor. The solicitor could give you advice. No, we don't think those restrictions are enforceable. Go on and do whatever you think you need to do to set up your business or to work with your new employer. Or from the business point of view, yes, we think they are enforceable. You can go after this employee, but the court may disagree. And I had a situation, a client rang me the other day as an individual who was on a new issue, but they talked about their previous experience where they'd taken legal advice, been told the restrictions weren't enforceable by their lawyer, but the other side still pursued them and still dragged them through up to the High Court to get to try and rely upon them. And ultimately, the individual won and they were held not to be enforceable, but, you know, being dragged through the litigation process and the civil courts for the best part of 12, 18 months, having to pay your own legal fees up until the point that you get them back because you've won, not really, you know, what you want to be doing, particularly if you, as Joe said, your focus wants to be on a new business or starting a new job. There's a couple of other questions coming in here with regards to, once someone's mentioned settlement agreements, that is something that can give a lot more weight to restrictive covenants, because obviously the employee is taking legal advice on them and should be being explained the content of them by the solicitor. And if they're signing that, then really it's deemed that they should know what they're signing, and therefore they carry much more weight. Now, sometimes Michael and I, again, when advising employees on settlement agreements, will say, look, we don't think these are enforceable, but it's actually probably more likely that they will be than they would have been had they just been in your contract of employment, because, you know, you're sitting down with me, listening to, and also the company's paying for it. So that is a way that it can be, they can sort of give you a more of a boost in terms of enforceability. Still no guarantees though.
I think you also sort of get the opposite effect, where I know I've advised employees on settlement agreements and said, look, listen to me, you're signing up to these quite, you know, onerous restrictive covenants, and they're like, yeah, all right, whatever, and they're not really they're not really interested. They want to sign the settlement agreement, they're interested in the money they're getting, not necessarily interested in the ancillary points. And even where I've said, you know, you are going to be bound by these restrictive covenants, they look enforceable to me, albeit a judge would need to make that determination. They've ignored me and then gone on and essentially breached them. That's happened to me at least once, I think. And they've come back and said, oh, I've just had this letter from my former employer after I signed the settlement agreement. Well, it was there in your contract and I advised you on it, and obviously that I need to make sure I've advised properly. But you know, that can happen as well. So yeah, I suppose, yeah.
The other thing that's that can commonly happen is if the employer breaches the employment contract prior to it being terminated, or terminated by the employee, then that can mean that the restrictive covenants fall away. So, for example, say you have a contractual bonus scheme and you fail to pay the bonus, say, for example, and the employee resigns and says, you've breached my contract, which you haven't paid me my bonus, that was a fundamental breach, and then goes to a competitor, and you say, well, hang on, you've got 6 months restrictive covenants. Well, the employee will say, well, yeah, I did have. He may also say, yeah, I did, but they're not enforceable. But even if they are enforceable, you breached my contract first, therefore you can't rely upon them. So if you have got restrictive covenants in the contract, you do need to be careful that, you know, quite often, I've just actually done it myself for a client, is that the client brought a constructive dismissal claim because he's getting hammered on the potential breach of restrictive covenants. So we're saying, well, if you allege the breach of contract, bring the constructive dismissal claim, and then that's going to give you a bit more leverage in terms of how we, you know, carve it out if we do get a settlement. So there's all sorts of tactical things that can be done from that point of view. Yeah. Joe's actually asked there, Michael, what happens if you have restrictive covenants which you want to change and there's a promotion?
So yeah, so it's just if people can't see it, you know, what happens if you need to change restrictive covenants due to an internal employee promotion, but the employee doesn't want to sign them? Trying to think if I've come across that directly in my practice. I don't think I have, but I think the principle would be the same as any change of terms and conditions.
Yeah.
The first thing is, if you're offering an internal promotion, it may well be very appropriate for, you know, all companies have some kind of promotion system. It may be very appropriate to suddenly put restrictive covenants in someone's contract if they've got more responsibility, more client contact, that kind of thing. So that's the first thing, is to make it clear why, I suppose, in terms of discussion, making it clear why you want those restrictive covenants, why it's appropriate for their new level of seniority. And you know, discuss and negotiate that way. Obviously, you know, you can say that the promotion and the pay rise is a condition. You know, that the restrictions are a condition of the promotion, presumably the pay rise. And ultimately, if they refuse, then you have the kind of normal options of changing and varying terms and conditions. If you can't get agreement, then ultimately you can do the fire and rehire maneuver, and essentially say, look, in that case, we'll dismiss you and rehire you on the new terms. That carries a risk, of course, of unfair dismissal claims if you've got more than 2 years service or any other.
That was a massive risk.
Yeah.
You have to have a very, very, very strong business reason for needing the restrictive covenants.
Absolutely.
To threaten to terminate somebody's employment and offer to re-engage with them to sign up. I actually know of a organisation who turned up one day at the office with a set of new contracts full of restrictive covenants and asked everybody to sign them. And the staff turned around and said, well, what are we getting for these? And there was no consideration offered. And therefore, even if they signed them, I don't think they would have had any bearing to the, wouldn't have been an addition. And I certainly think duress would be an interesting argument for the employees as well. I'm conscious of time, we are running out. Someone's just asked there, in advising on a settlement agreement, would you try and gain an increase in the settled amount to offset the restrictive covenants? Yes, that is a tactic that employees use to try and get more leverage. So, okay, you've offered me this, but I'm actually not